when you have a juvenile case, the child is under the age of 18, and there are issues that arise with respect to the high school and disciplinary action that can be taken by the high school or the middle school or the elementary school, as the case may be. And often the school has its own, quote, jurisdiction to kind of resolve the issue as they deem fit per their own disciplinary procedures. But what that creates is a complication with the criminal case, because they want a statement from the kid that they can make part of their own disciplinary file, so they can take action against the kid in terms of school. But you're always concerned when you're facing a criminal matter about what you say can and will be used against you in a criminal case. So very often juvenile cases we end up handling hand in hand with the school procedure, because it's the only way to protect the child on all fronts. But, and I say this to clients all the time, just because the law treats you as an adult at 18 doesn't mean that every kid has become an adult at 18. I think that cases with, I call them kids, but 18-year-olds to 25-year-olds tend to be quite prevalent, because that is a stage in kids' lives where they're kind of going out into the real world on their own and testing their wings. And sometimes, they run into circumstances away from their parents that has a huge impact on the rest of their lives that they wouldn't have had the judgment at age 19 to have thought about. So under the age of 18, we end up handling expungement matters, but we have a lot of cases where the kid is over the age of 18, but not very much over the age of 18. And so, they've got their whole lives ahead of them, and it's critical the way that you resolve these cases in a fashion now in adult court that doesn't follow them for the rest of their lives.